Hello, welcome to our video lecture series for Module 4-C. As you know, Module 4-C is on the matter of land acquisition under RA 6657 as amended. Now, we proceed to land acquisition as a discussion because we have already dispensed with the preliminary discussion in Module 4-A, which is on the introduction. And we already know what lands are covered as we have discussed in Module 4-B. Now, having identified the lands which are covered under RA 6657, we are now ready to discuss, to identify, to analyze rules, principles, and jurisprudence on the matter of land acquisition under RA 6657. So, for this purpose, we will discuss these four major and key topics. All right. First is on registration in relation to landowners and uh, lands which are identified as agricultural. Then second, which by the way is the bulk of our discussion, is on on the matter of modes of acquisition. And of course, we will be discussing the modes of acquisition one by one. Uh, and then since we are on the subject of acquisition, and we already learned that acquisition under RA 6657 and such agrarian reform laws as held in the case of Association of Small Landowners versus Secretary of DAR, acquisition is an exercise of the power of eminent domain, and therefore, by virtue of the requirement under the Constitution, this acquisition must be coupled with payment of just compensation. If not, the uh, condition precedent to the acquisition should be the payment of just compensation. And also, because in this module we will talk about acquisition, we also need to discuss the matter of retention limits. Because retention limits, as we know, is a right on the part of a landowner whose land is covered and is being acquired by the state for purposes of agrarian reform. And so it's just right and proper for us to discuss also the rules and principles involving retention limits or retention rights. All right. So let's start with registration. Very simple registration. It's under the law. It just states that a landowner, all right, uh, must register, no, in accordance with the provisions of RA 6657 within 180 days from effectivity of the law. Right? Now let's point out first. Now let's discuss first the meaning as defined under RA 6657. Now, for purposes of registration, what does landowner mean? Okay. Under the law, under the relevant provisions of RA 6657, a landowner is either a natural person, a juridical person, or a government entity. All right. So there may be three kinds of persons here: natural persons, juridical persons, meaning corporations or such other mga persons which are created by fiction of law, and government entities, because as we've learned in module 4-B, this law RA 6657, unlike PD 27, covers not only private agricultural lands but also public agricultural lands. So government entities, insofar as they own and hold agricultural lands, they are considered as landowner for purposes of registration and acquisition under RA 6657. Now, what's the common denominator among natural persons, juridical persons, and government entities? All right, the common denominator when they are considered as landowner is that these three persons, okay, either own agricultural lands or they claim to own agricultural lands, in which case they are identified as landowners who under the law must register, register with the Department of Agrarian Reform as landowners. Of course, under the provisions of RA 6657, the registration must not only involve the identity of the landowner, but also such other relevant information and data concerning the agricultural land. All right. We will not be identifying these aspects, these data, because that's just there in the law. We can just easily look it up. What is important here is to know, right, that a natural person or juridical person or a government entity who owns agricultural land as defined under the law, or who claim to own agricultural lands, are identified as landowners, and therefore they must register with the DAR within 180 days from the effectivity of RA 6657. All right? So 180 days from June 15, 1988. That's such a short period of time, no, to effect the registration, right? And so we can ask, is that a disabling provision of the law, such that because of the short window within which landowners as defined under the law may register, does that effectively limit the acquisition of the government? And essentially we can ask, because there is such a short window to register, does that mean that landowners who failed to register within the 180 days of the effectivity of the law are not anymore covered, are not anymore affected by RA 6657? The answer is no. Of course, no. Because had this been the case, agrarian reform would be limited, okay, very limited, to such landowners who voluntarily register themselves and their land holdings. All right, and if you put that power so much on one party in relation to agrarian reform, it's like you're rendering nugatory the entirety of the law, the whole framework of the law. So, what then is the purpose of registration? Now, what then is the purpose of registration as required under RA 6657? Now, the purpose of this is initially to encourage landowners to give the necessary information to the government for purposes of agrarian reform. It will be easier for the government to receive information, to receive data, than to go out there and conduct investigation, conduct ocular inspection, etc. So this is an opportunity for the landowner to help the government identify. But of course, it's not just the for the sole reason of helping the government, because registration within the 180-day period under the law is for the purpose of, I mean, registration in that period will entitle the landowner to incentives. All right, because if the landowner registers under the DAR pursuant to RA 6657, it's a voluntary act of registering himself as a landowner and the land holding that he owns or she owns. All right, and in order to encourage landowners to do just that, to voluntarily register, the government gives incentives to these landowners, no, as determined by the Presidential Agrarian Reform Council. But unfortunately, the resources in the internet and in the books that I have are bereft of any data as to what these incentives are, and rightly so, because the entitlement to incentives are is just for that 180-day period, for landowners who registered for that 180-day period, and which I doubt many landowners did register. All right, but can we say therefore that if a landowner does not register, he or she is still covered under the law? Of course, yes, because it's not registration which determines coverage, diba? It's the definition under the law. It's the provisions under RA 6657 which determine coverage under the law. So what then is the effect of not registering? So the effect would just be non-entitlement to the incentives, right? Non-registration will not result to non-coverage. All right, it just results into non-entitlement of the benefits as determined by the park. Nonetheless, no, notwithstanding the non-registration, that landowner will still be considered as covered so long as the land that he owns is an agricultural land, all right, as determined by ocular inspection, as determined by such investigation as required by jurisprudence and the rules. All right, so bear in mind, registration under RA 6657 is only for the purpose of allowing landowners to voluntarily register themselves as landowners, and of course their land holdings as agricultural lands, as which are covered by the law. No, in exchange for that voluntary act, in exchange for making it easier for the government gives incentives. All right, but if a landowner does not register, it doesn't mean that that landowner and his or her land holdings are not covered. It just means that that landowner is not entitled to the incentives as identified by the park. All right. Okay. Now let's proceed to the modes of acquisition. As I said, the gist of our discussion is on the modes of acquisition, no? Because under RA 6657 there are three, originally three, but now reduced to two, as we will discuss later. All right, the original three modes of acquisition under RA 6657 are: first, voluntary land transfer; second, voluntary offer for sale; and third, compulsory land acquisition. All right, so we will try to discuss these modes of acquisition, but just to give you an overview, the majority of the discussion under this topic would be on compulsory land acquisition, because most rules that have been formulated are on compulsory land acquisition, simply because this mode of acquisition is the one which involves the exercise of the power of eminent domain. As you can see, right, voluntary land transfer and voluntary offer for sale, they are, as the words, as the names would suggest, voluntary, and therefore the landowners themselves willingly parted with their property, which are covered under RA 6657, in which case it's not anymore a coerced transfer, it's not anymore a forced transaction. And being not a forced transaction, being not a coerced transaction, it does not technically fall under the concept of eminent domain, right? Because the exercise of eminent domain is characterized as a forced acquisition, a coerced acquisition, compulsory acquisition by the government, whether the landowner likes it or not. All right? So let's try to discuss voluntary land transfer, voluntary offer for sale, and compulsory land acquisition. Okay? Okay? Voluntary offer for sale, voluntary land transfer, and compulsory land acquisition. Now, what does voluntary offer for sale mean? All right. Voluntary offer for sale means that the landowner, all right, uh, offers a portion of the covered lands to DAR for voluntary sale. All right. Note that it's only a portion because the offer must exclude already the intended area which would be retained by the landowner. So not the entirety, all right, but a portion which is now outside of the allowed retention limits, as we shall discuss later on. Okay. Note also that under a voluntary offer for sale a mode, the landowner offers the covered land to DAR, right? And it is DAR which buys the property. Okay? And so therefore, this offer to DAR must be accepted by the DAR. Alright? Because it's an offer for sale. There's no sale yet. There's no contract yet. As you have learned in your obligations and contracts, of course, right? There's no contract unless there's meeting of minds. So this offer must be accepted first by the DAR in order for there to be a meeting of minds. Okay? Pending the acceptance by the DAR, okay, the offer is revocable at any time before that acceptance. But once the DAR accepts the offer, of course, there's already a meeting of minds, there's already a contract. Under the rules, that offer will no longer be revocable. Alright? Attorney, why does a landowner want to voluntarily offer the land for sale to DAR? No? Why does one who is being deprived of his or her properties want to voluntarily part with the property? Okay, in order to encourage such voluntary modes of acquisition, because if there's voluntary modes of acquisition, it's the whole process would be streamlined, if not shortcut. All right, because in a voluntary offer for sale, the government will not have to expend so much resources in the procedure to acquire. As we shall see later on, the procedure to acquire compulsorily is rather tedious. It will take too much time, whereas if it's a voluntary offer for sale, all you need is the landowner to offer and then accept. The DAR should accept, and then execution of the documents, and of course surrender of relevant deeds of title, or I mean muniments of title, such as most common a transfer certificate of title, and that's it. All right. And in order to encourage this streamlined mode of acquisition, the law grants incentives to landowners who voluntarily offer their lands for sale. All right, such as again, we will not be enumerating what these incentives are. Just know as a principle that if a landowner voluntarily offers his or her land holdings for sale, then that landowner will be entitled to additional mga incentives, no, such as no additional cash payment. As you know, in the case of Association of Small Landowners, diba? The Supreme Court said that in this revolutionary kind of expropriation of exercise of eminent domain, cash payment, payment of just compensation may come in forms other than cash. All right, and because of that, landowners will be given a variety of mga considerations as just compensation. Okay, not just cash. So here, if you voluntarily offer for sale, you at least, no, as a landowner, you will at least get this incentive. No, one of them is, for me, the most enticing incentive would be this additional 5% cash. No, when we are talking about huge land holdings which could amount to hundreds of millions, 5% could mean a lot of money, right? Could mean hundreds of thousands, if not millions still. Right? So that's an incentive for the landowners to voluntarily offer their land holdings for sale. So that's voluntary offer for sale. Right? Now we go to another voluntary kind of mode of acquisition, because here, no, in a voluntary land transfer, the landowner, all right, voluntarily agrees with the qualified beneficiaries, no, voluntarily contracts with qualified beneficiaries directly. All right, and such a voluntary agreement with qualified beneficiaries will have to involve the covered land, right, the covered agricultural land. And once they agree on the terms, once they agree on the contract, then there will be a direct transfer from the landowner to the qualified beneficiary. All right? But of course, the DAR should be there in order to ensure that the contract is not oppressive, that the farmer, the beneficiary, is not oppressed by the terms of the contract. All right? Here, it does not involve the state paying money. All right? Because as a general rule here, direct transfer man siya, it should be the qualified beneficiary who would pay. All right? But then, because the Land Bank of the Philippines is mandated to finance mga transactions, transfers under RA 6657, then the Land Bank of the Philippines may extend loan to qualified beneficiaries, and the loan, the proceeds of the loan will have to be directly given to the landowner, and the qualified beneficiary will pay in amortization, of course, no, in installment basis to the Land Bank of the Philippines. All right. So here, it's like a direct transfer, and then as you will recall in our previous discussions, the reason, the spirit of agrarian reform is to grant ownership, diba? To emancipate the tenants, no? To give them, to vest in them ownership rights. And so this mode of transfer, voluntary land transfer, is also identified as one because it is also in accordance with that spirit of agrarian reform. All right? So we have two kinds of voluntary modes of acquisition. No, how do we distinguish them? How do we identify one from the other? All right. In order to compare, no, just a little ano lang, murag illustration of the comparison of how they work uh, as a mode of acquisition. In a voluntary offer for sale, as I discussed a while ago, in a voluntary offer for sale, the landowner offers the covered land to the DAR, right? And it's the DAR who will acquire the property on behalf of the Republic of the Philippines. All right. And the DAR, representing the government of the Republic of the Philippines, will have to turn around and transfer the acquired property to the qualified beneficiary, right? While in a voluntary land transfer, okay, the landowner directly contracts with the qualified beneficiary, while the DAR is just there acting in a monitoring capacity or supervisory capacity to ensure that the terms of the contract are not oppressive against the qualified beneficiary. All right. If you can see, if you can observe, no, there's no transfer of the landowner to the DAR and then the DAR to the qualified beneficiary. In fact, under voluntary land transfer, the landowner still has a direct contact, direct connection with qualified beneficiary, right? Which is, as we try to recall, not not the tripartite system of agrarian reform as we've discussed, right? So much so that this voluntary land transfer was discontinued, no, by the amendments under RA 9700, no. This voluntary land transfer, insofar as the landowner can directly contract with the qualified beneficiary, all right, and can dictate the terms, even though there's DAR, okay, even though there's DAR, because as the sad fact is that there may be some cases where the landowner will have the DAR on its side, all right. The landowner will have advantage over the qualified beneficiary insofar as the DAR is concerned. All right, I'm not saying that's the case for for every instance. All right, but there may be instances in which case the qualified beneficiary, although it is still under RA 6657, will be left with a contract, with an agreement that is essentially not favorable to qualified beneficiary. All right. So realizing this, Congress amended RA 6657 via RA 9700. All right. Abolishing voluntary land transfer, and because as you can see here in voluntary land transfer, the contact between landowner and qualified beneficiary is not broken. In fact, it's still there, and the landowner can still dictate the terms of the contract. All right. So that means voluntary land transfer is not anymore allowed in the present. Does that mean that all the previous voluntary land transfers are nullified? No, of course. All voluntary land transfers which have been executed by virtue of RA 6657 before it was amended by RA 9700 are considered as valid. They are enforceable. They will not be disturbed. Okay? But after RA 9700, voluntary land transfer cannot anymore be validly entered into by the landowner and qualified beneficiary. Now, the cutoff date is June 30 of 2009. All right. So that leaves us now at present, that leaves us now with only one mode of voluntary transfer, which is voluntary offer for sale. Okay. But there are three modes, di ba? Original, 3 modes. 2 voluntary and then 1 compulsory. Usa na lang ka voluntary and therefore there's also there's one voluntary and therefore and also there's one compulsory mode of acquisition. Okay? Compulsory acquisition because it's involuntary, it's forced, it's coerced, okay, which means that this mode of acquisition now involves the exercise of eminent domain. All right, now in relation to compulsory acquisition, we ask what are the rules, what are the principles, what are the applicable jurisprudence in terms of compulsory acquisition. Okay, we shall answer all these questions in the next part of this video lecture series. See you there.